Welcome back to Retire at New Heights with Johnny Roberts. We're in the middle of a little four-episode series on legacy, trusts, and estate planning with a special guest. We are picking up here on the second part of this limited series. We have been having a rollicking conversation about all of those topics. And Johnny, I'm going to let you pick up right where we left off.
So, Frank, quick rehash, man. We talked about, I mentioned the three pillars, and you kind of were going into detail about that, about trust. Once again, forget about the money and the properties and all that stuff. That's important parts of why people want to do it, but no government, no public, and speaks for you when you can't, whether you're dead or sick or whatever it may be. So, you had talked to the last episode, you were getting into, man, what does a will do? How the government gets involved and can just take your money and uh, all that kind of stuff. They get a percentage of it because of their fees and court costs and all that. And you were just going to head into what does a trust do that's different? You know what I mean? What does a trust do that's different? And the first thing that I'll say that I thought was funny you said, because we talked about it off air last time, but you mentioned who wants to go to a courtroom? You know what I mean? It's like only attorneys do, and because it's a room without windows. Everyone think out there, if you're really been in rooms without windows, those are at asylums and jails and stuff. So we don't want to I don't want to be in any rooms without windows. There's no reason to go to those rooms. So a trust will keep us out of there. Take it away, Frank. What they do that's different.
Okay, very good. So first of all, a will. Having a will is better than not having a will. It's a last will and testament, a will, they're synonymous, same thing. So a will is a wish document. It will tell the court what your wishes are. But if anyone challenges it, then it becomes a full blown, like a lawsuit. It's going to be a debate in the court that could drag on for months and sometimes years as to how the state is going to be settled based on a will that is contested. But assuming no one contested, and today with split families, you never know, stepsons and daughters, you just never know what can happen. But let's say there's no contesting of a will, then typically the whoever's the presiding over the probate court will do whatever the person has said, which would be the person that set it up, and then the executor of that will make sure that the distributions take place. So that's really all they do is they make sure that your creditors are paid. They make sure that the estate goes out according to what the will said. If there's guardians, they assign a guardianship for the minor child or for adult or disabled child. All of those, that's all that probate court does. As soon as it's over, the distributions go out. It's done. Over. So now let's look at now if you don't have a will, it's based on state laws called intestate. Intestate means that the state has rules for your estate if you don't have a will. That's the reason I at least tell people at least get a will. At least in having a will, you're going to have some say so over what happens. Otherwise, you leave it up to the state, and the legislators in your state have already passed laws that says this is the way it's going to be handled. And some of your estate could go to people that you don't even like. So there you go. Now let's go to a trust. How is a trust? A trust is different because it's a contract. It's not a wish document. It's where you're sitting down or you and your spouse sit down and you decide who gets what. You do that in a will too, but it's a wish document. You decide who gets what, not only who, but when. Court doesn't. Court just says probate's over, distribute it. So you're deciding who gets it, when they get it, and how they get it. What do I mean by how? How means that if it comes time for a distribution to one of your heirs, and that heir is going through a problem like a divorce or bankruptcy or some addictive habit or whatever, then it will be held in trust until that problem has gone away. Or maybe they're just turned 18 and oh my gosh, they just got an inheritance, and by the time they turn 19 is gone. So when is very important. How? So these are things that a trust will define so that you can make sure that your estate is managed not only while you're living, but when you pass according to your wishes. And those wishes are documented in a contract. So there's no court hearing necessary, provided you make sure that your titled assets are named into the trust. A titled asset is any asset that you own that you have your name on. Obviously, real estate, bank accounts, insurance, automobile, all these things have your name attached to it, which means those are titled assets. So you have to make sure that they're funded into the trust, which is just a name. It's a paper document, basically. And so you're not losing it. You own the trust. You have just determined that when you pass away, the trust is able to distribute it because you're no longer around to sell the transfer or sign the seller's agreement. The trust will do it for you. Those are the primary things that a trust will do on your behalf.
One thing you mentioned, and I think, and tell me if this makes sense too. I love analogies. You've used a lot of them, but having a trust, doesn't it kind of like, especially you're the parents, it stops a fight before it can happen. Generally, like when I got kids, it's like you see your one kid pick up a stick, and you got three or four of them running the back. You're like, "Hey, put that stick down. Give it to me. What did I just do? I stopped the fight before it was going to happen." Now, sometimes they may never pick up sticks and they'll be fine, but we're going to tell them never pick up a stick because I want to prevent something bad from happening as a parent. And I think the trust kind of do that generally too. And obviously, there can be attitudes and people frustrated, but you can't you kind of control that dispute and that as far as on the legal side of things and the fights over certain things by having a trust within because we never think that's going to happen. But if you think about it and you have more than one kid, your kids fought as kids and they get aggravated at each other still as adults. And when emotions get high with, death and, properties or sickness and illness and money and all that, man, things can happen to the best of people that can kind of change that. So all that to say, am I correct in that analogy, kind of like what you're saying?
100%. And I'll give you an example. First of all, once a will has gone through probate and it's done, I've had attorneys tell me that when they read the will in their court, in their office, legal office, many times fights break out. One of the best stories I've heard was mother had left a vase. Some people call him a vase, to a daughter, and they're in the attorney's office, and the one daughter says, "No, she left it to me," and the other daughter said, "No, she left it to me." And they got into an argument, and one of the daughters took the vase and threw it down and busted it up and said, "You take yours and I'll take mine." That actually
Oh,
happened. And so, yes, it can create a lot of strain on the family because they start arguing about it. With a trust, it's a contract. So if a beneficiary, the only people that are going to attack a trust would be beneficiaries that think they didn't get what they should have, or someone that got cut out that didn't get what they expected. But when you challenge a trust, you're challenging a contract. And it's very difficult to challenge a contract that's been signed, witnessed, and notarized. You have to prove that that contract is fraud. What sets a contract aside? Fraud is the number one reason for contracts to be set aside. So it typically, the only time trusts are challenged would be if it's a very, very wealthy family and someone got cut out, and that person that got cut out sues the trust. And oftentimes, the real beneficiaries that are getting millions will pay their attorney to go settle with them and get rid of them. They're like a pebble in my shoe. Get rid of them. So
yeah.
that's reality. It's very difficult to challenge a trust because it's a contract under law. And when you do that, and even our documents say that if someone challenges it, if you were supposed to get something and you lose your challenge, then you lose whatever you were going to get. So you're going to sacrifice it. So it's you're spot on. Yes.
I think I like to next episode. I want to kind of talk about that third thing I brought up because we kind of covered the government and the privacy part about it a little bit. I want to talk about the concept of speaking for you when you can't, right? Whether it's if you're sick or obviously when you pass away or something like that. So I think next episode, Frank, kind of think about some thoughts along those lines, man. How important that is because if you don't have a trust, that really can't happen. Like you said, it's a wish list, but with that
Right.
contract, it's like, man, mom, dad are communicating exactly how they want this to be laid down,
Right.
or if they're sick in the hospital, or whatever. So I think next episode, Caleb, I'd like to, man, let's talk about some of that about, speaking when I can't and why a trust does that and what it can say for me, kind of on my behalf, right?
Yes.
Absolutely. We'll be
Absolutely.
back next time
Absolutely.
to talk about that.
Cool.